the inherent jurisdiction of the High Court is outstayed.
The principle of inherent jurisdiction entails the constitutional power of the High Court is provided for in section 171, is amplified by the High Court Act. In terms of the constitutional jurisdiction of the High Court, it is actually jurisdiction over any person, any matter within the borders of Zimbabwe, including even financial jurisdiction. It doesn't have any limit, unless where it is actually excluded by any statute. That principle has been considered by a number of cases, but I will mention the case of Chokura Iswanda versus Chinemute, whereby the court in that matter was actually considering the issue of the exclusive jurisdiction of the Labor Court and the inherent jurisdiction of the High Court. The question was whether or not the High Court can exercise its inherent jurisdiction over labor matters, and it was decided in that matter that there are instances whereby the jurisdiction of the Labor Court can be excluded, and whereby the High Court can exercise inherent jurisdiction over even any matter which is excluded in Section 89 of the Labor Act. Why was it decided so? It was discovered that it's only the High Court which is...
Sorry, can you answer the question? Just answer the question. What that principle means and the instances, the three instances in which it is outstayed.
Thank you, CJ. I will proceed to the instances, but to repeat myself, inherent jurisdiction implies a situation whereby the High Court is unlimited and fatal jurisdiction over any matter. In the instances that it may actually exercise its jurisdiction, it can exercise jurisdiction on review powers. That is, it can review any decision of any lower court. It can also entertain matters to do with the constitutional issues unless they are a preserve of the constitutional court. Then lastly, it is a court of first instance on specified cases in the criminal matters. Thank you, CJ.
Yes, the second question also has two parts. The first part, name two situations provided for under the High Court Rules 2021 in which an order or judgment of the court may be rescinded. And B, what two requirements in respect of each type of case must a judge address before rescinding the order or judgment?
Thank you, Chief Justice. With regard to a situation whereby the court or the High Court may resign its own judgment, that is provided for in the Rule 29 of the High Court. Rule 29 subsection 1 and Rule 29 sub-rule 1b provides for instances whereby a court can resign its own decision if it was made in an error or by mistake. It also proceeds to say that it can vary or correct its own decision in the event that there is a error, be it typographical or mathematical error, which doesn't change the circumstances of the judgment. Then it can also vary, resign, or correct its decision in the event that there is an agreement by both parties. And if parties agree that there was a common error which actually transpired during the proceedings, the court may resign or correct its decision. Further, if there is a proper default judgment which was entered in the absence of another party, by way of an application by the affected party, the court may consider that application and resign its decision. Thank you, Chief Justice.
The third question has three parts. The first part, what do you understand by the concept of presumptive penalty? Then B, what is the difference between a presumptive penalty and a minimum mandatory sentence? Then C, state two effects the sentencing guidelines have had on the criminal justice system.
Thank you, CJ. Presumptive penalty actually comes in a situation whereby there is an offense whose penalty is already prescribed. In that instance, if the penalty is already provided for by way of a statute, in the absence of any discretion of the presiding officer, it is presumed that once that person or accused person is convicted of the specified offense, this penalty applies. Then there is an issue of minimum mandatory sentence. That one is a mandatory sentence which is actually allocated to any criminal offense, whereby if an accused person is convicted and in the absence of special circumstances, the presiding officer is mandated to impose that minimum mandatory sentence. Then there are sentencing guidelines which ought to be followed by a judicial officer. The first one is that there are guidelines which are, if it is a statutory offense or if it is actually well guided in the statute, you have to follow what is actually stated in the statute. But if it is an issue whereby the presiding officer is to exercise his or her own discretion, then you have to follow the principles of sentencing, like retribution, which seeks to punish the offender, or actually the principle which focuses on actually trying to bring back the offender into a situation whereby he can or she can be a good or a better citizen through that type of sentencing. Then there is an issue whereby the sentencing can follow precedents or be guided by the trending sentencing procedures that are in the case laws. I think those are the basic sentencing guidelines that ought to guide or formulate each judicial officer when it comes to sentencing.
The last question has two parts. The first part, state three principles that govern the conduct of virtual hearing proceedings in the High Court. And B, what is the role of a judge in the adoption of a virtual hearing as a proceeding in the High Court?
Thank you, Chief Justice. When it comes to virtual hearings, it should be known that every part is supposed to file the court processes online. When that has been done, when it comes to the issue of setting down the matter, it can also be done through notice on each and every party's portal. When it comes to the issue of appearing or attending to the hearing, the judge is supposed to be logged in the portal, whilst the parties are also expected to do the same. When that has been done, the parties may make their submissions virtually, whilst the judge is being assisted by the registrar and the technical experts in conducting the proceedings. But in all essence, the proceedings remain the same as those of a physical court in all intents and purposes. So a virtual hearing means that parties may appear virtually according to the scheduled time to proceed with their hearings as actually afforded them time by the registrar.
Thank you. I will now hand you over to the other commissioners for further questioning.
Thank you, CJ. I have two short questions for you. From the information you placed before the commission, it appears like you were last a magistrate some 17 years ago. Is that so?
Thank you, Deputy Chief Justice. That's correct. It was actually in 2007 when I left the bench.
And then as a practicing legal practitioner, you indicate that you have appeared before the Constitutional Court and the High Court.
That's correct. I appeared in the Constitutional Court in 2014.
In?
2014.
2014, that's some 10 years ago.
Yes.
And in the High Court?
In the High Court.
Which High Court is that? Bulawayo?
It's Harare.
Harare High Court, yes.
Yes. It's actually the other matters I am handling are still ongoing, but it's actually from 2022, 2023, I've been appearing in the High Court.
Yes, thank you. And your view is that that experience has prepared you adequately for assuming the post of High Court judge?
Indeed, Deputy Chief Justice, I started appearing in court as far back as 2004 when I was a law officer with the Civil Division. I spent more than a year of intensive appearance in court at the admin court in Tare. Thereafter, I spent much time in court whilst I was on the bench as a magistrate. That was from 2004 to 2007. Thereafter, I was actually in the corporate, but in the same. While it's in the corporate, it depends with the nature of the corporate you are. There are also cases where you'll be taken to court, to tribunals, and so forth. And when I was with the CAPS Holdings, I had a lot of incidents. Where I was going or attending courts, mainly labor court, because I was the legal advisor there. Then when I joined ZUPCO, I was also...
If I could just interrupt, I was interested in your experience as a judicial officer and as a legal practitioner actually appearing in court. Yes, thank you.
Thank you, Chief Justice, Mr. Gatawa. My question is more generalized. You may be aware that corruption has become a menace in society, the very society that we are expected to serve. Now, as a judicial officer, how do you intend to enhance the fight against corruption in the judiciary?
Thank you, Commissioner Mabiza. Indeed, I admit that corruption is a serious scourge affecting our societal fabric as of now. As a judicial officer, I understand they are specialized division that deals in each and every court that deals with the issue of corruption or related to corruption. So, in the same vein, if I'm appointed to the bench, I will contribute directly or indirectly through presiding over cases of similar nature and to make sure that they are disposed of timelessly, and a serious actually message has been sent home to would-be offenders through actually imposition of well-guided or well-deserving penalties, but that depends with the issue of evidence that before a judicial officer, because it needs several stakeholders to fight corruption. It's not a one-man band issue, but I'll encourage through judgment and so forth the other stakeholders on how best they can actually improve on the issue of tackling or fighting against corruption.
Thank you.
Thank you, Chief Justice, and good afternoon, Mr. Gatawa.
Good afternoon, Commissioner.
Now, my observation is that from your CV, there's been a lot of movement from one place to another. In some instances, we're having a year. In some instances, we're having less than a year, right? And this seems to me to be different engagements at different times. In fact, I counted about 9 movements in 9 years. Now, this goes to what the Deputy Chief Justice asked you. In my imagination, I believe that if you join an organization, you would have to learn the culture and the workings of an organization before you could, and that is in my imagination, before you could actually say you have moved to another organization and so forth and so on. Right? Given that scenario, would you not reflect a little bit and say that perhaps you may not have consistent, grounded experience to be ready to be in to assume the position of a judge, given that there has been a lot of movement around? Would you still think that you are grounded?
Thank you, Commissioner Moyo. I wouldn't want to think so. Actually, in instance that will solidify my position to be a good candidate, to be actually considered to sit in the bench, in the sense that my experience is quite fused. I didn't remember, if you may agree with me, that it doesn't take a person 2 or 3 years to acquire experience in the same organization. Within 1 year or so, you would have actually learned a lot within an organization. When you exceed to 2, 3, 4 years, it will be just repetitive, especially considering the fact that the law or the legal principles are almost the same. So you'll be ending up repeating what you've been doing from the first time you joined the organization and then on the consecutive years. But as a judge, you do not have to be well versed maybe in the one branch of law. You may be a magistrate today and spend 10 years.
I think I'm answered, Mr. Gatawa. Thank you very much. All I wanted was you are confident that, look, you are ready.
Thank you, Commissioner.
Yes, thank you. Yes.
Thank you, Chief Justice. Do you realize that if you do become a judge, you will be doing the same thing for the next 20 years?
That's correct. Thank you, Commissioner.
And yet you seem to think after a year you get bored and you must move on to something else.
I don't know if I actually indicated or intimated the issue of boredom, but I said you can amass enough and requisite experience within a year. What I was doing when I was actually moving from one organization to another, I was actually trying to prepare myself on such time as this. So when I arrived to where I wanted to be, there is no way I can be bored, because this is what I've been preparing myself to do all along.
And yet you've hardly practiced. You said you appeared in the Constitutional Court in 2014. Did I hear that correctly?
That's correct, Commissioner.
Was that during your 1-month stint with Tamuka Moyo?
It was a period of around 9 months when I stayed with Tamuka Moyo. Maybe there should be a contradiction in the CV, but I stayed for 9 months with Tamuka Moyo.
And in that 9-month period, you managed to institute a constitutional matter and see it right to the end and appear and argue in court, in the Constitutional Court?
Commissioner, when I appeared in the Constitutional Court, I remember the bench by then was led by the late Chief Justice Josiku. It was a file which was referred to me when it had already progressed, because the organization I was representing by that time, they had been self-acting. So I only took it to argue, because they couldn't proceed to argue the matter. And when I took it to the Constitutional Court, it didn't take 2 sittings for the determination to be arrived at by the Constitutional Court.
Did you win it?
No, I didn't win it. Why? Because the matter was actually brought by self-actors, and they had already done something which we could not actually remedy at the last instant.
And then you say that you still have a court order for quantification of damages against the Public Service Commission and the Minister of Industry and Commerce, and you got this order in 2023. Is that correct?
That's correct, Commissioner.
This order you got in 2023 relates to your employment with the PSC when?
Actually, I was employed by the Public Service in 2012. Then I was transferred from the public service to industry and commerce. That's where my contract was actually terminated through early retirement.
In 2014?
Yes.
And you fought that case for 7 years until you got an order for quantification in 2023?
At first, I was engaging the commission.
Yes or no?
That's correct. That's very correct.
Thank you. I've got no further questions, Chief Justice.
Thank you, Honorable CJ. From your CV, it appears you qualified as a lawyer in 2003. You graduated as a lawyer in 2003.
That's correct, Commissioner.
And come 2024, you are an associate at Gijima Attorneys.
Indeed, Commissioner.
Don't you think you have underachieved? 20 years down the line, you are an associate, you are not a partner.
I think if you were to revisit my CV, Commissioner, you find that when I became an associate, it was a comeback because, as I said, I was preparing myself to rejoin the bench, and I had actually pending applications which I even placed with the JSC in an effort to come back. I spent time in the corporate, and when I wanted now to say this is now ripe time for me to go to the bench, that's when I joined myself to the practice. So when a lawyer in the corporate practice and a lawyer in the private practice, they are not different. So it's not an underachievement as you may want to look into it, because there is no difference. It's only that you are dealing with the different laws in different places.
I see. I also noticed you have a master's in international relations. Were you considering pursuing a career as a diplomat or something like that?
Thank you, Commissioner, for the question. There was a time when there was a vacuum in our universities whereby they were not offering any masters in law. And what was being offered at UZ by that time was actually international law, and I discovered that I can take it and grasp certain fundamental principles regarding to international law and maybe public international law, but that was not the course I wanted to do. I shined to register with the UNISA because I wanted to do the local university.
Thank you.
Thank you.
Yes, thank you, Honorable CJ. Mr. Gatawa, we are in receipt of adverse comments made about your suitability for appointment by a professor, formerly of Bindura University, that is, his name is Macleans Mzumar. His allegation, I'm sure you're already aware of it, is that you manufactured two resolutions authorizing staff at the university to depose to an affidavit to be used in the labor court. Can you briefly give us your comments of those allegations?
Thank you, Commissioner, Judge President. Indeed, there is an allegation to that which also took me by surprise, but I wasn't surprised per se because that issue, I am advised by our external lawyers that it was actually once raised at the labor court because that issue pertains to proceedings between the good professor and the Bindura University. So when I was appraised of that issue, I actually raised it as well with the registrar, and if you analyze in my response, that is, it has been placed before you, paragraph 11 of my response addresses that issue. There is a registrar at Bindura University who is responsible for servicing council meetings, taking minutes and producing council resolutions. When there is need for a council resolution by any authority, it's the registrar who produces a resolution, because he's the one who knows the council members from the chairperson of council, deputy, and so forth. So in that case, I didn't and I do not deal with the resolutions. What I only did was to alert the office of registrar that there is a pending case at the Labour Court, and there is a corporate institution, you need to attach a resolution. And it was actually sent to the external lawyers as per the normal procedure. If you find, or if you revisit again my response, it's not a sole case where Professor Mzumara has been a litigant. There are more than 8, actually there are 12, and there have been placement of resolutions or council resolution in all those court processes. But what I can say is that I do not deal with the resolution, but I can liaise with the registrar on whatever document of the university that is needed by external lawyers.
Yes, so what are we to make out of this complaint? We can't resolve it. We can't try the allegations. What are we to do? How are we to approach? You haven't cleared yourself.
Thank you. I think it's not easily necessary to consider it in the following sense. This is a matter which was being handled or is being handled at the Labour Court, and that is court is actually competent enough to deal with any complaint of that nature. So if there is a criminal, maybe a complaint against it, or by the person who is alleged to have been, or whose signature was forged, there should be a complaint against a particular person who is said to have forged a resolution, if ever it was forged. So I do not have a dispute. There's no dispute before you, but there's an allegation.
Do you agree with me that these adverse comments go towards your integrity, your honesty?
Commissioner, I wouldn't agree more with you on that, in the sense that I'm saying I do not deal with the board resolution, it's the registrar. So there's no way it can affect my integrity, because my duty is only to stand in between the university and the external lawyers. So there's no way I was going to be involved in the production and even the transmitting of the resolution within council members or circulating them for their signatures. So that is an allegation, and it should remain as such.
Thank you. You've adequately explained yourself. Thank you, Honorable CJ.
Yes. Thank you, CJ. Good afternoon.
Good afternoon, Commissioner.
Are there any publications that you have ever written? And if not, in fact, maybe the question would be, I see that you do not have any publications to date. What are your limitations?
As a legal advisor and at times a corporate secretary, I had internal what I can call training manuals which I've produced, and I'd trained a number of executives in the health sector and even in the public sector, and I was responsible for producing those, but they were not for publication, they were for only for internal consumption. I did one.
So maybe the question was, you have no publications other than training.
That's what I indicated, Commissioner. Thank you.
What are the limitations?
There are no limitations per se, but it's only that I was not yet ready to write articles or to do articles because of the nature of my job by that time.
Thank you. Thank you, CJ.
Yeah, thank you. Yes.
Thank you. I don't know what's up.
Hello, Mr. Gatawa. Are you still attached to the Bindura University
Yes, Commissioner.
on a full-time?
No, not on a full-time, but on advisor role.
On an advisory role?
Yes.
And I think that will be all that I wanted to understand.
Thank you, Chief Justice. Mr. Gatawa, at what point in your life did you decide you wanted to be a judge?
Thank you, Commissioner, for the question. From 2003, we were given an option when I actually transferred from the Public Service Commission to Minister of Justice to either join civil division permanently or going for the bench. And I chose the bench because I was looking forward to the idea of joining the bench as a judicial officer at a higher level. So the decision was made long back, as far back as 2003. I had other options. I had an option to join even in private practice, I had an option to remain in the civil division, but I chose to join the bench in preparation for that. That's why I became a magistrate.
Thank you. Thank you for the response, but hearing you answering the questions that were being asked, and also in terms of your whole career, there's nothing that seems to me that you're preparing yourself from being a judge, a decision that you made as early as 2003.
Thank you, Commissioner. As I indicated earlier on that I tried even a comeback as far back as 2014, and I got a clearance from the Ministry of Justice and the Commission, so that I'll be able to be readmitted in the bench. But by that time, I think there was a silent policy in the JSC whereby they were not keen to absorb back people who once left the bench, even though they were letters of clearance. So that on record, I think is also on record. It was actually an attempt, but that is silent. It is not visible in the CV.
Thank you, Chief Justice. Nothing further.
Thank you. Yeah, it's okay now. Yes, thank you. We have come to the end of your interview. You are excused.
Thank you, Chief Justice.